What must the promoter do after project is registered? Create his web page on RERA website. State project's registration number and other details on his page. Every quarter he has to update his page and update the following details: number and type of apartments booked, number of garages booked, list of approvals granted or yet to be granted or revoked, progress in the project, other information as ruled by the RERA body in future. All advertisements of promoter shall state the project registration number and the URL or internet address of the page of the project in the RERA website. When promoters allots a unit to an allotee or books a unit for the allotee, he shall provide the following information or documents: sanctioned plans, layout plans, specifications that have been approved by RERA. Promoter shall declare the dates of the completion of the project and the dates when the water, sanitation, and electricity would start running in the project. This section 11-4 is a long one, and promoter has to do many things to retain his credibility in the market. This is a solid punishment to developers who were honest for decades together. Firstly, a promoter has to fulfill obligations, responsibilities, and functions under this RERA law and rules made under this law. Secondly, a promoter has to fulfill obligations, responsibilities, and functions as agreed by him in the agreement for sale, and as promised to the association of allotees till the apartments, plots or buildings are transferred to them. Thirdly, till the common amenities are handed to association or till the roads are handed to the municipality or to the panchayat, he has to fulfill all functions, obligations, and responsibilities of erecting, running and maintaining them. The proviso to section 11-4 is very vague. It says that promoter is liable for all structural defects even after the sale deed. But for how long? My view is that this clause needs engineering precision, and the types of defects need to separated, and for each defect the warranty period has to be fixed separately. Promoter has to get occupancy certificate, completion certificate, or any other document that is needed to perfect the title of the each allotee and hand it over to the association or each allotee. If the promoter is a lessee and not the owner of the land, then he has to provide the registered lease deed and related certificates and documents to show that rents and other charges have been paid up to date. Since the promoter has a recurring liability to pay the dues here, so I presume that allotees need to provide the proof of payment of rents and taxes every month or year, as the promoter has agreed to pay the landowners. Till the association of allotees take over the maintenance of the project, and after completion of the project in all aspects, promoter has to maintain essential services at reasonable charges. This section is vague and does not specify the charges and the service standards in detail. Lawmakers cannot afford to be so imprecise and casual when they frame a law. Promoter has to enable registration of a society, once majority of the plots in the project are booked or latest within 3 months after the majority booking is done. Promoter shall execute a registered sale deed in favor of the allotee. Promoter shall maintain at his cost each of the units and common areas and pay the local taxes, until the promoter transfers each of them to an allotee or the association of allotees. In case the promoter fails to fulfill this obligation for any unit, he will continue to be liable for those payments. In case the promoter is sued to recover those sums, he shall be liable to pay even the litigation cost incurred. Section 11.4h claims that after sale deed registration of a unit, the allottee is not liable for any charge created by the promoter on that unit. This is contrary to another law, which says that registered encumbrances or charges over any immovable property get transferred to even a purchaser, who purchases a portion of that property. As per Section 11.5, promoter has a right to cancel the agreement of sale only as per the terms of that agreement, so that document has to be carefully drafted with all the automatic triggers. But the allottee can sue the promoter if the cancellation is not in accordance with the agreement or if it's unilateral and without sufficient cause. The promoter shall maintain all details and records as specified from time to time.